Would you enjoy earning more than your peers? What about specialized training and networking opportunities that will help you advance your career faster towards success? Members of AACE International enjoy these benefits and much more. AACE gives its members the tools they need to prosper. From electronic magazines and newsletters to our series of professional development webinars, members benefit from specialized expert knowledge. We host online communities to allow members to network, post questions, discuss topics, and provide professional development. Our members have 24/7 access to world-class resources, AACE's body of knowledge, and virtual library. Members receive discounted rates for conferences, continuing education seminars, certification, professional development presentations, and AACE publications. AACE arms our members with the technical tools and expertise to complete projects on time and on cost, while meeting investment and operational goals. We have been the leader in the cost and management industry since 1956, with members in 100 countries and over 80 local sections. Success is not a big step in the future. Success is a small step taken right now. Find out more at web.aacei.org/membership and join AACE International today.
So thank you so much. And now it's the time for Matthew finally to speak. Here you go, Matthew. The floor is yours.
Thank you very much, Saad, and good evening, everybody. Bismillah ar-Rahman ar-Rahim, as they say in this region. Well, everybody, welcome to this collaboration between the Chartered Institute of Arbitrators and the American Association of Cost Engineers. We're very happy to have this as one of our first collaborations, and I hope as many of you as are here tonight will be interested in finding out a little bit more about the CIArb. At the end of the talk, I will give you a brief introduction to the rest of the CIArb committee in Qatar. We are fully established in Qatar and the QFC, and we're here to help promote arbitration as a form of alternative dispute resolution, and to assist with the resolution of disputes, particularly in the construction industry, but certainly not exclusively so. And I think that's reflected if you look at the membership of our committee. We draw committee members from various professions, and not just from those of us who are focused on the construction profession. But today's topic is obviously going to be of interest to those of you in particular who are involved in dispute resolution. And I was going to give you a little bit of an introduction to what it's like to conduct an arbitration in a virtual hearing, via a virtual hearing. I imagine that some of you will have been to a real hearing, and so I'm going to try and introduce you a little bit to what it's like to do it in a virtual setting. Before I commence, obviously, I just wanted to thank our sponsors and partners, the Qatar International Court and Dispute Resolution, and their Chief Executive Officer, Faisal Rashid Al Sahuti. The QIC DRC are the sponsors and partners of the Chartered Institute of Arbitrator in Qatar, and I think it's no exaggeration to say that without them, it wouldn't be possible for us as your institute to deliver the things that we managed to deliver in Qatar. So we are very grateful to the QIC DRC for all that they do, and for any of you who are interested in finding out more about the QIC DRC and who they are and what they do, then of course I'd be happy to answer any questions about them. So on to this evening's talk, and here's an overview of kind of what I was going to take you through tonight. So what is a hearing? Let's start at the very beginning, as they say, in The Sound of Music, for those of you who like a good Christmas film. Number two, do I need a hearing? Number 3, why can't I meet in person? Topic 4 is going to be what is a virtual hearing? 5, what is a virtual hearing protocol? That will be something that you will start to hear more and more about. What is different about a virtual hearing? What are the differences between real hearings and in-person hearings and virtual hearings? What is an electronic bundle, for those of you who are unfamiliar with that? And then finally, I'll introduce you to the CIArb, and then we can handle any questions you may have. Right, so without further ado, well, what is a hearing? A hearing at its most basic is a meeting where the parties and the arbitral tribunal, who are the body who are there to hear your particular dispute, well, it's a meeting where they meet. And basically, the tribunal hears the parties' arguments, hears their arguments and hears their evidence. And we see this, this concept is defined in a number of places. Starting point actually is the law. And when I talk about the law, of course, here I'm going to be talking about things within a Qatari context. So I'm going to be talking about the civil and commercial arbitration law, that's Law 2 of 2017. And specifically for hearings, we go to Article 24, which says, the arbitral tribunal shall hold hearings in order to enable each party to explain the subject matter of the case and to present its arguments and evidence, or in order to hear their oral submissions. So that is what a hearing is. It's actually specified in the law, so you don't need to fish around too hard for the definition. I mean, actually, of course, hearings are also referred to in key institutional rules. Now, I've only picked these two because they are perhaps the two we see most frequently in Qatar, and they are the ICC rules. So Article 26.1 says, when a hearing is to be held, the arbitral tribunal, giving reasonable notice, shall summon the parties to appear before it on the day and at the place fixed by it. So that's the relevant rule in the ICC rules. Again, the QICCA rules, the KICA rules that some of you will be familiar with, the Qatar International Centre for Conciliation and Arbitration. And there it's Article 18.3 of the KICA rules. The arbitral tribunal shall hold one or several hearings for the presentation of evidence by witnesses, including expert witnesses, or for oral argument. So that's what a hearing is. And I suppose the next question you might want to ask is, well, do I need a hearing? If I have a strong case, do I have to go to hearing at all? Now, Article 24.1 of the law did suggest that a hearing was required, but in fact, in most legal systems, including in Qatar, those legal systems recognize it is possible to have a hearing on a documents-only basis. In fact, I was a little bit naughty. I didn't set out all of Article 24.1 in my earlier slide. Here's that slide. Here's that article now in full. The arbitral tribunal shall hold hearings in order to enable each party to explain the subject matter of the case and to present its arguments and evidence, or in order to hear their oral submissions, unless the arbitral tribunal considers written documents and statements as sufficient, or the parties agree otherwise. So in other words, in the law, it is perfectly possible for parties to have their arbitration heard on a documents-only basis. And that's where you can see there the wording, unless the arbitral tribunal considers written documents and statements as sufficient. Now, just pausing there are, of course, arguments that we can all see and have been deployed in Qatar. The most obvious one is Article 135 of the Constitution about the right to be heard. And so I think it's certainly my experience, at least in Qatar, that it's very unusual to run arbitrations on a documents-only basis. However, I think, as if you read the law as it's currently written, I think it's certainly arguable to say that you can have a hearing on a documents-only basis. And we know that that is a practice that is regularly performed throughout the world. Certainly in my home jurisdiction in England and Wales, where I originally trained, documents only processes, certainly documents only arbitrations or documents only adjudications, are extremely common. In fact, in adjudications, it's the default. You tend to be documents only unless there's a particular reason why you need to have a hearing. And again, it's worth pointing out that most institutional rules adopt a very, very similar process. And they take a similar position. So here we go. ICC rules, it's set out in Article 25(6) of the ICC rules. The arbitral tribunal may decide the case solely on the documents submitted by the parties, unless any of the parties requests a hearing. So that's a slight variation, in fact, as between the law and the rules. And obviously, if you have submitted your arbitration to the ICC rules, well, then one of the parties will always have the right to demand an oral hearing. KICA rules, again, I was a little bit cheeky. I didn't set out the full text of Article 18.3, and in fact, it very closely follows the law. Well, in fact, I suppose you could argue that the law followed the KICA rules. The KICA rules are in fact a much earlier document. They were created in 2012. KICA rules, you can see they're highlighted in red. However, the arbitral tribunal may decide whether to hold such hearings or whether the proceedings shall be conducted on the basis of documents and other materials. So as you can see, there is that legal and rules-based process whereby a tribunal, usually with the parties' agreement, can decide to hold a particular hearing on a documents only, a particular arbitration on a documents only basis, or whether it needs to have an oral hearing. But I think it's safe to say, and it's worth observing, that if one of the parties demands a hearing, says, I want to have a hearing, it would be a very, very brave tribunal that said, no, I'm just going to do it on documents only. So if we're going to assume, as some people often say, I want my day in court. So this is the Qatar International Court, Lord Thomas being sworn in as the presiding judge. I want my day in court is, of course, a refrain that we lawyers often hear, and a party who feels aggrieved wants to be heard. It's a sort of a basic principle of justice in most countries around the world. Of course, it's worth pointing out that in an arbitration hearing, you're not in court, you're in an arbitration hearing, but the principle is the same. People want to be heard, they want to have their day. Well, so why can't I meet in person? Well, here's the main answer at the moment: COVID-19. COVID-19 has obviously been a major disruptor, I think it's fair to say, to the ordinary process of many of the things that we understood to be common practice. So even tonight's lecture, if this had been last year, I'm sure I would probably have been in a room with you somewhere giving you a lecture in person, because that was how we always used to do things. And the same goes for arbitral hearings. It was the common thing to do, was that everybody would get in the same room. And I'll be honest with you, it never even occurred to me until this year to have a hearing anything other than in person. That was how I had always done. I say that, I mean, obviously as a practitioner, I had been involved in, you would often have several meetings, usually case management conferences or pre-trial reviews, pre-hearing reviews, in which there would be a meeting, but because those are usually earlier stages during the arbitration process, and in particular, those are not stages in which evidence is tested. Instead, they tend to be a matter of sort of legal and oral submissions. Tribunals and parties had got very used to delivering those types of meetings and presentations via telephone, or sometimes video conferences if you had a particularly innovative arbitrator. But a full hearing, a full oral hearing, I had never met anybody until this year who had ever participated in one of those, who had ever even thought about participating in one of those. It was seen as so radical that there was no reason really to think about doing that. Well, of course, as I said a moment ago, COVID-19 has been the great disruptor. It has very, very substantially disrupted the way in which we have traditionally done a lot of business, certainly in if you like, in the legal sector, in terms of our meetings with clients, in terms of hearings, if you have trials and hearings, be it in litigation or arbitration, or even presentations like the one I'm giving to you today. And so we have all suddenly become a lot more familiar with the technology, things like Zoom, for us to be able to deliver these types of meetings and presentations virtually, via a video conference system. And I'm pleased to say that I am now one of the lucky ones who has done a full oral hearing, a multi-day hearing in which there was testing of evidence, cross-examination of witnesses of fact, expert witnesses, and lots of interventions and dialogue with the tribunal. So having now been through that process, I'm going to try and share with you today a little bit of the things that I picked up from that experience. And I think it's fair to say that tribunals and parties have already begun that process of postponing hearings, but the postponement of hearings actually has been happening since March 2020, because really since the COVID pandemic bit in Europe in a big way, and let's be frank, a lot of arbitrators, particularly a lot of arbitrators who practice in this region, are Europeans. Well, since the arrival of COVID in Europe in a big way, and the lockdowns that happened during March 2020, that had a substantial and significant impact on how hearings were going to be run and when hearings would be run. So the immediate reaction of most of the legal arbitral community was, well, let's postpone, we'll push it back a few months, and we'll see where we are in the summer. I think that was probably the approach of most of the people who were involved in the arbitration process. But that was what started to happen in March 2020. However, by the summer, when arbitration was still not able to happen in person, because in reality, most of the restrictions that had come into place really hadn't lifted. There was then a realization that people needed to find alternative means in order to have their hearings and in order to make sure that people's diaries weren't just going to be consistently postponed and postponed. And as a result, the tribunals are realizing that their future diaries are being booked up. So to give you an example, I have hearings currently arranged in March 2021, May 2021, and July 2022. Now, for a variety of reasons, the March hearing is currently on ice, so we haven't really talked about that one. The May hearing, we are already having dialogue between the parties and the tribunal about putting systems in place in order to have that hearing conducted entirely virtually, because we are already beginning to think that there's a realistic prospect that the COVID restrictions may not have lifted. Yes, there will be some rollout of vaccines available in some parts of the world. So we've had the news today from the UK that we've started the vaccination process against COVID in the UK. But the UK is the first country in the world to start doing that. And it may take other areas, some time before sufficient numbers of vaccine are available and before vaccination programs have been sufficiently rolled out. So I can certainly see hearings really up until the middle of the summer and perhaps beyond, increasingly moving towards that online platform. I think it's also worth saying that for those of us, practitioners and arbitrators and clients alike, who are concerned about environmental concerns, well, again, I can certainly see that virtual hearings are here to stay. They're going to be a phenomenon that we will all be dealing with in our professional careers from now on. So I think it's a good idea to get used to virtual hearings as a concept. It's not to say that I think we have witnessed the end of the era of in-person hearings, but I do think in-person hearings are going to become a rarer phenomenon, and they may be saved, if you like, for those very special hearings where, for a variety of reasons, you must have everybody in the same room together. So that's why you can't meet in person. And as I say, not all hearings can be in person. So what is a virtual hearing? You may be wondering. Well, I think the first thing to say is that a virtual hearing is in lots of ways just like an in-person hearing. And that's really the idea of virtual hearings. They want virtual hearings to be perceived by parties, by practitioners, by arbitrators as near as possible to the real thing, as in the in-person hearing, because in that way, there is, if you like, that continuity of process and that continuity of reliability of outcome. That people know what they're getting into, and they have trust and confidence in the process, that at the end you'll get the same sort of result that will have emerged from the same sort of process. So that is why I think there's a lot of those sort of questions about virtual hearings being like in-person hearings. So you still have a tribunal, you still have witnesses, you still have experts, and you still have lawyers. All of that is exactly the same. The main difference is really that instead of everybody being in the same room physically, everybody assembles in the same room virtually. So if you can forgive an early Christmas cracker joke, we're not all in the same room, but we are all in the same Zoom. That's really the only difference. Now, one of the things I mentioned earlier is a virtual hearing protocol. And you're probably thinking to yourself, well, what is that, and what does that mean, and how's that come about? So I think the starting point is to say that a protocol is an agreement that everybody enters into, usually in the run-up to a hearing, and it's really a process and a system that everybody agrees to ensure that the virtual hearing runs smoothly. And so both the parties and the tribunal know the mechanics of how the hearing is going to run and all of the various procedures that need to be put in place to ensure that. The ICC were actually pretty quick in sort of understanding the need for a protocol and how the protocol would come about. And so, in fact, they issued this guidance note. It's not a particularly catchy title. It's called the Guidance Note on Possible Measures Aimed at Mitigating the Effects of the COVID-19 Pandemic. But if you do a Google search for it, you're looking for a document that was dated the 9th of April 2020. That's when the ICC issued. It's fair to say, actually, the ICC were not the first. The leaders, if you like, on virtual protocols were Korea, and they developed a document known as the Seoul Protocol. And the Seoul Protocol first emerged after the Asia Pacific ADR conference, which was in fact held in November 2019. So, interestingly, if you like, the genesis of virtual hearings and virtual hearing protocols predates COVID. It was something that the Korean arbitration community and the Asian Pacific arbitration community was already thinking of, probably as a way to mitigate environmental concerns, so that we could start having hearings virtually, so that we didn't all have to be jumping on aeroplanes all the time to get to hearings in particular locations. So, what's in a virtual hearing protocol? I think a virtual hearing protocol, when parties and tribunals enter into it, it's really, as I say, it's to come up with a framework for all of the procedural elements that need to be addressed in a virtual hearing. And so they will be looking for certainty, or as near as possible to achieve certainty, on a range of procedural issues, such as, for instance, what platform am I going to use? Obviously, we'll come on to that, but it's the usuals: Zoom, WebEx, Microsoft Teams, and so on and so forth. Is there going to be a backup platform? What happens if your primary platform for some reason crashes? How do we ensure that that backup platform is available? The security of the platform is considered to be very important. I think it's still the case that arbitration is seen as a private form of dispute resolution, and so parties and tribunals are going to want to ensure that you can't just have anybody walking in accidentally into a room where a virtual hearing is taking place. So, getting the security of platform and knowing who the users are and being able to monitor the users, that's seen as an important part of the protocol. Obviously, there needs to be a system testing prior to the hearing. You can't just rock up on the day and expect the relevant platform to work. You have to ensure that there has been, a process of testing between everybody's different systems, to make sure everybody's systems are compatible, that everybody can hear each other, and that that works. And as I'll talk to you a little bit later, in fact, we're beginning to see VC providers that are going to be, beginning to come into the marketplace and provide systems. So that's not just the platform itself, Zoom, Microsoft Teams, etc., but it's actually professional providers who can run virtual hearings, and I'll give you a little bit of background on that as well. Who attends? In other words, how do you ensure that who is attending the virtual hearing protocol and how they announce their attendance of that protocol? In other words, how does the arbitral tribunal take a roll call at the beginning of of each day at the arbitration? Because that's an important part of the process. Indeed, you would get that in a physical hearing. Obviously, in a physical hearing, the arbitral tribunal can see who is in the room. It's not the same with a virtual hearing, and there are one or two, if you like, one or two interesting aspects of that I think it's worth thinking about, and I'll tell you about that in a minute. Now, one obvious aspect of who attends is, well, who is in a room with a witness? This is, I suppose, one of the, if you like, one of the more interesting, maybe even controversial aspects of virtual hearings, because of course in a physical hearing, well, where the witness is there, he sat in the actual hearing room in front of everybody and in front of the arbitral tribunal. So unless he had he was James Bond and had specialist equipment such as some sort of earpiece that nobody could see, you would know that he was in the room, he or she was in the room being interviewed by the lawyers, by the arbitral tribunal, and that there was nobody that was helping them or coaching them through their evidence. Now, in a virtual hearing, of course, that's a lot more difficult to police. And so one of the things that we are seeing in virtual hearings is, for instance, protocols being talked about whereby, for instance, a witness is often required to turn their webcam around to show that there is nobody else sat in the room with them. In other words, to ensure, if you like, the sanctity of the process, and that the process is the same in a virtual arbitration as it would be in a normal arbitration. So we've seen that protocol certainly emerging. Sometimes you may even get 2 webcams in an arbitration hearing room, one looking directly at the witness, and then in this case there will be another camera behind me here pointing the other direction, so that if you wanted to, you could look what is on the other side of my computer and see that there was nobody sat there. So that's a good example of something that you might need or want to cover in a virtual arbitration protocol that you perhaps would never have necessarily thought about, or you wouldn't have to think about in a real hearing. In a similar sort of way, you're going to need to talk about the position of the screens and the cameras and the backgrounds. So obviously with witnesses, I've talked about the camera facing one way and facing the other way. Backgrounds, having a neutral background, I think, is actually a very important thing. If a witness puts on their virtual Zoom background and it's a tropical island, well, somebody who is cross-examining them, or an arbitrator, might find that pretty distracting. So actually, you're going to want to have everybody have ensured and agreed that they understand, what is going to happen in terms of backgrounds, in terms of cameras, and in terms of what sorts of screens are available. And again, we'll come on to that topic because that can be very important when it comes to documents and looking at documents. And here we go, straight on to documents and e-bundles, and even administering oaths. These are all sorts of things that you're going to need to think about as you are putting your virtual hearing protocol together. Again, it's all part of ensuring that a virtual hearing is as similar as possible to a real in-person hearing. So who are the virtual hearing providers? And obviously, I've put up this slide because everybody's going to have heard of all of these. Well, I say all of these. I have not heard of Amazon Chime until today, so that was quite interesting. But pretty much all of the others, Blue Jeans, Zoom, WebEx, Teams, Google Meet. We've heard of a lot of these types of providers. However, certainly in my experience, providers for a virtual hearing are different from the platforms that we use in order for the hearing to happen. Now, an example of today is pretty straightforward because it's just me sharing my screen at you. We don't need to look at any other documents. Don't need to hear from really anybody other than me or Saad, and I'm sure Saad may fire a few questions at me at the end, but generally you just need to hear from the two of us. So it's pretty straightforward. We don't need anybody to host this beyond AACE, making everything available to you all as visitors. It's different, I think, and it is different for a virtual hearing because it's inherently a much more complex system. In particular, you're going to need multiple rooms to be available and working together simultaneously and in a synchronous fashion. And in particular, you need to ensure that the documents that you are going to be using in a given situation, in a given passage of cross-examination, that everybody is seeing the same document in the same way at the same time. And I think really that, perhaps more than anything else, is what we're finding is going to drive the decision-making around how you host your virtual hearing. So as I say here, it tends to be driven by e-bundle considerations, and there are some companies, here's a few examples, Epic, Opus 2 and Lloyd Michaud as some of the better known ones, and I'm not here to plug any of them. Other service providers are available, but those service providers, they can provide that if you like, that unified system of e-bundle and virtual hearing hosting together. You do get some who just host the hearing, so you may choose to split that. That might, in fact, occasionally be a little bit more cost effective. So you're getting your e-bundle from one provider because they're an e-bundle specialist, and then you get somebody else to host the hearing, as it were. And we're finding that, often it's the well-known hearing providers who are beginning to sort of step into that space. I mean, certainly for those of you who have ever been involved in any international arbitration hearings in London, you may well have heard of the IDRC or the AACE, the International Dispute Resolution Centre, which is on Fleet Street, and the International Arbitration Centre, which is in the city near the Old Bank of England. So those are two, Great Broad Street. So, those are two providers who have big rooms in London, and what they're saying is, well, you don't need to come to our big rooms. Instead, we can host you online as well. Spark, again, is another virtual hearing provider that we are aware of, that focuses on providing that virtual hosting platform. But of course, I think it's fair to say that you still need the video conferencing platform, so Zoom, WebEx Teams, something like that, in order to run, if you like, the software part of the hearing. But certainly it was our experience from the virtual hearing that we were involved with, that having somebody who was hosting everybody in one place and who was going to be able to, in particular, coordinate the hosting of the hearings, who appears on the screen with the electronic bundle, that was an absolutely critical part of the process to ensure that we had a smooth running virtual hearing. And certainly it was our experience that if you go to one of the recognized providers, that's absolutely what they can provide you. So, well, what's different about a virtual hearing? And actually, the reason I put this screen up was as you can see, you get lots of providers who are very good at providing a split screen for 4 people. Actually, of course, certainly for most arbitrations, it's very seldom going to be 4 people on the screen at one time. It's going to depend on how many arbitrators you have. But that's going to be an odd number. It's going to be 1 or 3. So to give you a good example, in the virtual hearing that we did, we always had 3 screens up, which were the 3 arbitrators. And then as a minimum, we needed another 2 screens, one of which, and this is on 2 images, if you like, on one of our screens. So we had 5 pictures on the one screen, which is the 3 arbitrators, and one of the counsel who was doing the cross-examination, and one of the witnesses. There was a brief period when you would have 6, because we had the 3 arbitrators, we had 2 experts and one of the barristers. But again, they were on one of the screens, and then the second screen was dedicated to the provision of the document. That was the e-bundle was on the second screen. So everybody had 2 screens in front of them so that you could have this process of speaking to the witnesses and speaking to the tribunal, and at the same time going to the relevant document that you were trying to take that particular witness to. So you needed to have those 2 screens, and then one of them split 5 or 6 ways in order to allow that process to happen. So that's a good example of where a virtual hearing and having a service provider who knows about how arbitration hearings run and the need you're going to have to split those screens, that's a really important part of the process. And of course, in this particular instance, you have, we were fully international in the sense that I think we had 1 arbitrator in France, 1 arbitrator in Dubai, 1 arbitrator in the UK. We had counsel in a different part in the UK, and then we had witnesses who were either in Lebanon or in Qatar. So everybody was sort of split round in numerous different locations, and it all had to work at the same time. And critically, everybody had to be looking at the same document at the same time. So again, I think that was certainly one of the lessons that we took away, was having that really, really sort of focused, dedicated relationship between the person providing and hosting the arbitration virtual hearing with the person running the bundle. And before I move on to the next slide, as part of that process, the person who was hosting was also doing the transcribing. because inevitably in any modern arbitration hearing, certainly in my experience, in almost all instances, you have a transcriber who is involved in the hearing. They are taking a minute of everything that is said in the hearing, and in particular a detailed record of whatever the witnesses say. So you have that. Again, they are very much wedded into that process, creating a live note. So actually, if I think to the virtual hearing that we had, essentially between us and our barrister who was running the hearing for us, I think our barrister had 4 screens in front of him. In fact, he had the 2 main screens, parties, documents, transcript over here, and then his own laptop with his own notes as well in front of him. So that's just a good example of how certainly virtual hearings, it turns us into, if you like, extras on the set of The Matrix or Star Trek, for those of you who are as old as I am and fond of those programs. Right, so what else is different about a virtual hearing? Well, I think it's we have to start at the same point. A lot remains the same. That is the idea. You're supposed to have as much as possible the same type of experience in a virtual hearing as you get in a real hearing. So you still have the process of cross-examination. You still have the barrister is going to be asking questions of his witnesses, and then the re-examination, and then the tribunal will have questions as well. As I have said already several times during this talk, having a good, efficient bundle, and inevitably, I would say, an electronic bundle, an e-bundle, that is absolutely key to the process to making it work. And I'll say a little bit more about the e-bundle in a minute. Now, I can give you a few, if you like, a few other pointers based on our experience of the virtual hearing, and I found it very interesting that what we chose to do was, there was no liaison between the parties to this effect, but that both parties arrived at the same conclusion and did the same thing, which was that the core teams, the core legal teams for each of the parties, we all got into the same room anyway. So we were virtual. It's virtual, Jim, but not as we know it. It's virtual up to a point. It's not fully virtual. It's not all of your team members in every different room. I mean, perhaps there will come a time at which we all end up doing that anyway. But certainly for this hearing that we had on this instance, the 2 core legal teams, the barrister, me as the partner leading the case, my associates, trainees, and in fact our expert witness, we were all in one room together. It happened to be in London. We then had a second room in Dubai. A second room in Doha with all of the key team members in that room. So that was the key client members and all of our key people in our Doha office. We did have some tech people, and one of our other team members was in Dubai. So we were actually split across 3 offices, but I would say the core team, for the purposes of that particular hearing, was all in one room together, and that is exactly what our opponents did as well. So I thought that was an interesting takeaway, really to help everybody communicate. Now, talking about communication, one thing I haven't said on these slides, I didn't put on the slide, but I remembered actually as we were sort of in the warm up to today's presentation, is that we also ended up opening a room together on WhatsApp, and we were using WhatsApp as a very, very efficient messaging system. So if we had comments or questions, or can somebody go and get this document, or where did the witness speak about that sort of thing, well, that was all dealt with via WhatsApp, so that we were not communicating via the main protocol. We were not using the chat function, for instance, on Zoom. Actually, that goes back to the protocol. In our protocol for the virtual hearing, everybody had agreed that we would disable the chat function on Zoom, so that there would be no chat, and that you would just simply be focusing on the hearing itself. So I'm certain that our opponents, just as we did, set up a WhatsApp chat room so that there was still that ability to have that chat function between the legal teams, between the clients in the various offices. I had a discussion with I think it was in fact with the barrister that led our hearing, and I think and he came up with what I thought was a very, very interesting and well judged comment. And he said, in his perception, the real difference is the difference between theatre and television, and I 100% agree with that observation. I think in particular, to give you a good example, in a real hearing, and perhaps I should move away from the phraseology of real hearing, because actually a virtual hearing is also a real hearing, it's just done virtually. But in an in-person hearing, there is a sense of theatre for any of you who have ever attended a hearing like that, where there is that, if you like, that tension, that focus on usually the barrister who is doing the cross-examination and the witness who's being cross-examined. There is that real sense of theatre between the two of them. The pressure, the tension builds, and often for the arbitral tribunal, they are there to try and pick up, the non-verbal signals that the witness is giving off. Perhaps he's shifting uncomfortably in his chair. Perhaps he's touching his nose or his face in a particular way, and the arbitral tribunal will pick up on these sorts of things in order to be able to tell whether they perceive that a particular witness may or may not be telling the truth, or at least the whole truth about a particular situation. And I think it is absolutely fair to say that much of that theatre is not the same in a virtual hearing. That doesn't mean to say that it's absent, it's just different, and there's a different atmosphere. I think what I particularly took from our virtual hearing, which was a surprise and a revelation to me, was the faces of the tribunal members in particular. And it was really obvious when a tribunal member did or did not like a particular argument or a particular piece of evidence, or something that a witness or a barrister had said during the process, and you saw all the the sort of the winces and the eyebrows and the little twitches became much more real and much more easily spotted via the virtual hearing and the virtual conference, because essentially all you are doing is you're focusing in much more closely on a person's face, because inevitably when we are using webcams, that's what you see above everything else. So I would say that was a real revelation to me, certainly, based on if I compare that to previous hearings that I've attended, and perhaps it's because I'm a bit short-sighted, but I do tend to try and wear my glasses. But even then, when I'm in a room with the tribunal member, I think it's fair to say that it's difficult often to see precisely the face of the arbitrator. Normally, you're picking up other, as I say, non-verbal signals about how an arbitrator might feel about a particular piece of evidence, because you can see it in the way they're sitting, you can see it in the tone of their voice or in the tilt of their head. These tend to be the things that you would see in an in-person hearing that you would not necessarily experience in a virtual hearing, as I say, because you are removed from each other, but that is replaced by the closeness of the webcam. So yeah, I would say the big difference there is that difference between theatre and television. So perhaps we will see the rise of the telegenic arbitrator. Those who have got a particularly good face, or perhaps even a particularly neutral face, so that you can't really tell what they're thinking, because at the end of the day, perhaps that's that tends to be, in my experience, what parties would rather like or rather prefer. So the final topic, and I can see there's been a few questions. What is an electronic bundle? And forgive a little Christmas related joke. I'm sure some of you may be getting a Kindle for Christmas. Well, an electronic bundle is not a Kindle. An electronic bundle is something very, very different. What an electronic bundle is, it's a pulling together of all of the key documents in a case, but then having an electronic platform that enables parties to show those documents to the witnesses and to the tribunal at the same time. And that is absolutely critical, because I'm sure, as all of those of you who know, who've been involved in disputes in the Middle East and indeed construction disputes globally, documents are absolutely the core issue, in my experience, of most disputes. And so certainly, if I was going to give you a takeaway tip from this talk, it's working with one of the professional bundle hosting companies, getting one of them to run and provide your electronic bundle, because I think unless you have that, that is going to place, I think, a very big burden on, particularly if you're a claimant, on having that ability to have your documents shown in the way that you would like them to be shown, so that you can be confident that the tribunal and the witness and your own barrister, all of you are looking at the same document in the same way at the same time. And that is, to me, that is the absolute heart of how a virtual hearing would work, and would work efficiently and effectively. And so, again, this was something that we found that we used one of the the well-known e-bundle companies, and exactly so that they could show the same documents simultaneously in different countries, and in particular that actually we all had the same, effectively the same, I suppose, using an IT term, the same GUI, the same graphical user interface. In other words, seeing exactly the same thing on the screen at the same time, so that when one of the barristers said, for instance, please would you zoom in on clause 5, that on the document screen it zoomed right in on that particular piece of the text, so that we everybody, tribunal members and witness and barristers, were all at the same time looking at exactly the same zoomed in piece of text, so that we were all focusing on the same thing. I think in my experience if I had a takeaway from the particular hearing that we had, it was extremely impressive working with one of those professional companies, because they had loaded everything up onto their platform, so that and then we had all agreed, again this was sort of part and parcel of the preparation of the virtual hearing protocol and the preparation of the virtual bundle, that we had agreed the same sort of same terminology, same user phrases for each document. So, for example, the statement of claim could be, bundle A, tab 1, page 1, and then you might have the statement of defense as bundle A, tab 2, page 25. That would be the sort of way in which you would do it. And then whoever the barrister was would have gone through his or her opening submissions and would have said, right, can I please take the witness to paragraph 28 of the statement of claim, and that's at A120. And really, with only a very, very short time lag, I would say probably about on average 10 to 15 seconds, the document provider would put up that exact provision at the right zoom on the screen, so everybody, tribunal members and barristers, are all looking at the same document at the same time, which I think from a perspective of efficiently getting through a bundle, to me that was a real revelation. I am old enough, sadly, to have been schooled in the ways of the hard copy bundle. That that you walk into a room and there are sort of 150 Libre Arch files all in grey boxes behind you, going from bundle A to bundle Z, and all the subsequent bundles, and having literally to go through those hard copy bundles, get out the Libre Arch, plonk it on the desk in front of the witness, and turn to the relevant page. If anything, I would say that the electronic bundle was quicker. It was quicker, it was more efficient, and of course, you don't have to chop down half a forest in order to achieve it. So, I certainly, I would say that I experienced what I could only describe as a Damascene conversion, and that frankly, I would be amazed if I ever use a hard copy bundle ever again. Because the electronic bundle was such a success. And just really to round off on this point about bundles, I think the reason I sort of leave it here, and I've focused this on my last point, is as I say to all of my clients, the bundles and documents are critical in construction disputes, especially in construction disputes in the GCC. It really is all about the documents. The documents are king. Documents. So what I always say to my clients, and I'm sure you have heard it from your colleagues in AACE and in other bodies, it is really all about the documents. Often the person with the best records is the person who prevails. So don't be like this. Make sure you organize your documents rather better. That really is the end of the main body of my talk, and I can see that there has been a fair bit of chat and various questions, and I'm going to invite Saad to take me through that. Before I do that, can I just take 2 minutes just to introduce you all to your Qatar and QFC committee of the Chartered Institute of Arbitrators, in particular to our president, Ahmed Al-Ansari. For those of you who are familiar with him, Ahmed is the manager of the technical office, so he's the chief technical officer for Ashghal. So is an extremely important figure within Ashghal and the huge program of delivery of works that Ashghal is delivering, as well as being steeped in in engineering and in the delivery of major projects. Ahmed is a real friend, I find, to the alternative dispute resolution world. He understands the dispute resolution process as part of the program of delivery of major infrastructure projects, and is a real true innovator in the space. Is always looking for innovative, interesting, cost-effective, and quick ways in which to to deliver good outcomes at the end of projects, and and adopting all manner of potential avenues for alternative dispute resolution. So that was why we chose, we are asked and wanted Ahmed Al-Ansari to become our president, and obviously I was absolutely thrilled when he agreed to do so. So he is and remains an absolutely pivotal figure in the Chartered Institute of Arbitrators community in Qatar. I'm the secretary, so I'm if you like, I'm the fixer and the doer. If any of you need anything done, I'm a pretty good person to come and see. Tamam Al-Akari, who is a well-known Lebanese lawyer based in Qatar, he is our treasurer. Sean, the two Seans, Sean and Sean, are our education gurus, and I think it's the reason I've got them both on the first page, and why we have two people delivering education is because, frankly, we see your committee sees education as an absolutely critical part of our mission in Qatar. What we are here to deliver, we're here to assist with education around further training and development, mentoring, studentship, around all aspects of dispute resolution and arbitration as a form of alternative dispute resolution. Katerina Stathi, as I mentioned to you at the beginning, we have been fortunate to draw figures from not just from the construction industry, and Katerina is absolutely a great example of that. She's focused on the biotech and the pharma industries. Certainly during the era of COVID-19, I'm sure, as we will begin to see, companies like Katerina's will become absolutely critical, in the delivery of all manner of projects, not just delivery of the vaccine, as we hope that rolls out. The rest of our committee, Abdurrahman Abdurrabo, one of our most senior members, a highly respected general manager of DAMAC, and he's focusing on membership. The youthful and very handsome Adib Mahmoud, who is another Ajral representative, and he's there to focus on our young members. Nurul Sabri from HKA, she is focusing on events. And then last but by no means least, your very own Saad Hegazy, and Saad is he handles our website and all of our PR as well. And then for those of you who are members or who are interested in thinking about becoming members of the CIArb, then I would like to introduce you to Franco. Franco is our head of admin. The rest of us, we are all fortunate enough to be unpaid unpaid committee members, and we assist the CIArb through our love of the Chartered Institute as a body, and to deliver arbitration. But Franco, he is actually the one guy who is he's paid to be there, but he's great as a result, and he's there to help all of you with any of your inquiries and any of your needs relating to the activities of the Chartered Institute. So he should be your first port of call. A little bit about me, but you've heard all of that already. So any questions? And thank you, shukran jazilan, to all of you. Please, well, why don't I hand it over to you, Saad? If I could see that there was a fair bit of chat during the talk. So if there are questions, I'll certainly be very happy to try and help.
Sure. Well, first, let me thank you so much for this amazing presentation. Actually, I think the topic is really critical because it started now to be the mainstream of the hearings. Like everyone is speaking now about virtual hearing, and a lot of people, even if they are experts or arbitrators or lawyers, they didn't actually experience it yet, as you have done in full practice. So before moving to the attendees questions, I have a few questions to you. First of all, I had to put this background to show a little bit of reality of AACE, since you exposed my involvement in the CIArb. Okay, so one question: do you think that COVID-19, because of the current situation, this will help more moving towards virtual hearing or document arbitration? Like, as far as I remember, when we discussed previously the CIArb and how they are having the theme of document or encouraging the document arbitration, especially in the small disputes, and this is not normal practice here in the GCC, and some people were, as you said, saying that this is legal requirement. So the real question is, the COVID-19 will help us going more towards documents arbitration or towards more towards virtual hearing? What do you think?
It's a really good question, and wow, I'm gonna get my crystal ball out here. My instinct is in our region, in the GCC, that we will see a move towards virtual hearings, not to documents only hearings. I am still of the view that, and it's it's deep rooted, I think, in a lot of in the cultural norms of the region. It's deep rooted in that sense of, if you like, all the way back really to, in fact, I think even back to the Holy Quran, we see instances where the Prophet, peace be upon him, talks about those situations where you would have an elder who would, if two parties are having a dispute or a difference between them, that they would go and see an elder, and that the elder would then help and mediate between them. So actually, you can see this in various sunnah and hadith coming from the Quran, that that concept of two people being heard by a third person, and an elder, a more older, experienced, wise person, is, if you like, hardwired almost into the kind of the concept of resolution of disputes in this region, and within the Arab world. So I think from my perspective, and we see that then obviously flow through into modern documents, as I mentioned, the Qatari, the permanent constitution of the state of Qatar, Article 135, which talks about the right to be heard. So that the right to be heard is simply the modern successor of those early sort of hadith and sunnah, about being heard. So my guess is that actually documents only hearings won't really catch on. They might a little bit, but they'll end up being, I think parties will be very pragmatic about it, and they will say, look, for the very, very low cost disputes, we won't have hearings, and we will just proceed without a hearing. But I think for everything other than that, you can still assume that hearings will take place. Just to give you, an idea of that, I am aware of a dispute that is across our books at the moment, where the value of the dispute is less than 1 million riyals, and there's still going to be a hearing. So I genuinely, I don't think that there is much appetite in this region for documents only, and I think virtual will replace in person.
Yeah, perfect. So the other question, which is maybe related also to the benefits of the virtual hearing. So as a barrister and lawyer and arbitrator and all these, and party involved in arbitration, and some of our people here as an experts, and even ourselves, we always have the issue of the extended period of the waiting for the hearing, because the parties are not, the arbitrators normally are very busy, everyone at the same time on the same country for the hearing. It was very hard to do. So do you think that with the virtual hearing, this is gonna shorten the time of the procedures in future, if it's gonna be the new norm?
It may a little, would be my guess. I don't know if it would that much, but it may foreshorten it a little. At the end of the day, the main drivers in my experience, for the timing of hearings and when they are going to take place, tends to be the volume of and complexity of the information that has to be addressed in front of the tribunal. So if a dispute is relatively straightforward and the papers are not overly voluminous, then it's usually possible to arrange the hearing in a relatively short time frame. To give you a good example of that, and again, not just driven by the volume of the documents, and if you like, the technical complexity of what you're dealing with, but also particularly the anticipated length of a hearing, because that has a big impact on how many days do you need, and therefore what kind of size of window do you need to find in the arbitrators diaries. So for the virtual hearing that I was involved in earlier this year, the hearing, the direction to have that hearing was only issued in May, So we went from having the direction, and to set a bit of background, we made an application to bifurcate certain issues. The application to bifurcate was granted, and therefore the tribunal then said, right, well, we need to, these are quite difficult and complex issues, we're going to need a hearing. And the parties in the tribunal agreed that we would need 3 days to be set aside for the hearing. So it was a question of then, when could we find 3 days? And we looked at everyone's diaries. And I suppose you're right, that's one of those issues where, because I think it was already anticipated at that time, because we were already in COVID by then, that it was going to be a virtual hearing from the off, that we would be able to pick a kind of just a 3 days, and you wouldn't need to leave any additional traveling time.
Yeah.
And where you've got, arbitrators who are in Europe, and they were all in Europe at the time, effectively you're going to have to find a day at either end, probably, if they're going to be in an in-person hearing in the region. And so as a result, we were able to say, oh, look, here's 3 days in September that everybody has free. And even though it was 3 extremely well-known and high-profile arbitrators, who have all got extremely busy diaries, and we were still able to find those 3 days in September. So we went from the decision being made in May to a hearing before the end of September. So yeah, you're right. I think you can get more flexibility as a result, but I think it's not the main driver. The main driver is still going to be how complex are the issues, and how lengthy is the hearing likely to be.
Yeah. So another related question, I think Abdul Wahid is reading my questions and he's asking the same questions. So did this attract an extra cost, or basically it might reduce the cost of arbitration, like overall the virtual hearing? Because you spoke about e-bundles, about the about like having platforms, hiring new things to be included in the hearing. This will attract a new element of cost, which increase the cost of the arbitration, or because of the deleted, like the big rooms for arbitration, the traveling for the arbitrators or stuff like that, it will reduce the overall cost for arbitration.
Good question. I think the only sensible answer I can give is probably swings and roundabouts. I think, in other words, some things become cheaper, some things become more expensive. So, for instance, with our virtual hearing, well, we didn't have to fly people from one location to another, so you don't have the cost of flights. You don't, thinking big picture, we didn't have the environmental cost of all of the people jumping on planes to go somewhere. You don't have the traveling time of the various people who are traveling, be they arbitrators or witnesses. So you've saved on that. You've saved on the printing out and creation, and the time you spend creating a hard copy bundle and somebody checking through all that. You save the cost of the venue, but the little pause of hesitation. Qatar is one of the few places, frankly, in the world where actually it's possible to get extremely good value, and sometimes almost free. I mean, the QIC-DRC have been real sort of have really shown their commitment to the establishment of Qatar as a venue for arbitration, because effectively, you can hire the rooms for really a nominal sum, as long as you're covering teas and coffees, and a few other administrative incidental costs, security, etc. But in overall terms, the cost of hosting a hearing at the QIC-DRC is extremely cheap. You compare that to, say, the IDRC in London. The IDRC, you're spending several thousand a day probably for hiring of different rooms. So so those are, as I say, those are all swings and roundabouts. You don't have to pay for people's lunches or teas and coffees. So those are all savings. But as you say, quite rightly, you've got then all of those other costs, the technical costs, the costs of identifying the service provider, the cost of the e-bundle, the cost of setting it up, the time you take to do all the virtual testing, the cost of the equipment, because you certainly need to make sure that you and all your teams have got the equipment. So overall, I think it comes out in the wash. I don't think it's much more expensive or cheaper. I think it costs about the same whether you do it virtually or in person. I strongly suspect that there would be a virtual provider jumping up and down with hard evidence of how it's cheaper to do it virtually. My perception was it was much of a muchness. That was my perception.
Yeah. Okay. So moving forward to what happened in the virtual hearing. So a few questions. Somebody asking about the recording, because plenty of the I would say hearing is recorded, but some of them, I don't know, videos, but most of them is typing, like hearing statements and like the stuff like that. So is this kind of I know it depends on the tribunal and the case by case, but do you think, like, if it's allowed to, is it allowed to record, is it like normally? And this is just for floor understanding. And if the recording is allowed, this is gonna help in future for referencing and for helping to getting more into the expediting the award?
Wow. I mean, this is probably, if not a full lecture on its own.
We have 10 minutes, and we need to take another more 2 questions.
It's possibly half a lecture on its own. The short answer is no, as in no. I don't think. I think you are going to find, in most instances, most arbitrators are going to say, no, you can't record. Why? So, as we all know, things like Zoom and WebEx and what have you, it's a button. You press the button and away you go. The computer program records the meeting or the presentation for you.
Exactly.
I think it's fair to say that is an absolute hornet's nest when it comes to GDPR in most countries in the world, the global data protection regulations. And GDPR is sort of started in Europe and has rolled out really from Europe and beyond. And again, most well, not most, but a large number of arbitrators and arbitrations have got, in some way or another, a European element somewhere in the mix. And then other countries, increasingly we're seeing in GCC as well, countries beginning to adopt GDPR type regulations. So the short answer is, can we use the record function on Zoom or Teams or WebEx? The answer is almost always going to be no, you can't. And in fact, that often will be addressed in the protocol that parties agree, that will say somewhere that you are not to record. It's one of the reasons why a transcript is taken, because you bring in a professional transcription company, they prepare a transcript, everybody can review the transcript and can agree on the transcript. The transcriber does have a recording, but it is a recording that only the transcriber controls, and it's only for them. And once the final version of the transcript has been agreed, the recording is deleted. So that's a very traditional way of looking at it. And again, it's if you like, it goes back to this idea of making a virtual hearing as close as possible to a real hearing. You do not go into a court, certainly in the overwhelming majority of European countries, and record the court session.
Yes,
now,
exactly.
The US, I do think the US does have a different approach, and the role of television in American courts. And obviously, if you really wanted to, you could have the trial of O.J. Simpson, and you could press record on your video recording, video recorder, and away you go. So it would be possible to do that, but so I don't exactly know how how those particular two worlds are going to collide, that sort of, if you like, that European and Middle Eastern concept of privacy versus that American concept of freedom of the press,
Yeah.
and how those two worlds collide. But for now, I think in our region, and certainly anywhere, any arbitrations that are involving Europeans in them in some way, I think you can safely assume no recording.
Yeah. So last question, which is inside the virtual hearing itself, before we move into the last question of today. Jack is asking about what guarantees the witness has an annotated bundle. So,
Yeah.
which is
Jack
very
is in
hard
my,
for.
I should say Jack is actually in my team. Jack and I worked on this particular arbitration. That's a
Okay.
question, but actually a very helpful comment, which is as part of the protocol and part of setting up the system.
Yeah.
You need to make sure that a witness doesn't have an annotated copy of a bundle in front of them. In other words, just as you would in a real hearing, you're not allowed to walk into the witness box
Exactly. Yeah.
with your own copy of your
Notes.
witness statement,
Yeah.
with notes and with flags and highlighting.
Yeah.
So again, another reason for using a camera to, so he can show that he doesn't have a copy of the bundle.
Yeah.
And again, another strong reason for using an electronic bundle, because there it's centrally controlled. You're all looking at just the one document, the same document.
Yeah.
Nobody's looking at their own special copy of the document. So that's, again, it's a really important point.
Perfect. So the last question, I think there are some other few questions, but we will not be able to take all of them. But I think this one is a bit different. I think it's he speaks about the time difference, like the time difference in arranging the virtual hearings and stuff like that. Would you think that because of the time differences and the difficulties on gathering everyone, which is the case, like doing the normal hearing, this would encourage, how first of all, how do you handle this? Second, this may encourage in future to hire local arbitrators or people from the same region to allow, better arrangements of the virtual hearing, which is maybe will be the new norms, as we say, in future.
It's a really good question, and the answer is. I think that the best way I could answer it is to use the phrase "the tyranny of the majority." So, in other words, wherever most of the people are, that becomes the relevant time zone. It's either the tyranny of the majority or it is the president who calls the shots. I've got a really interesting one coming up where the overwhelming majority of people are going to be in the Qatar time zone. One arbitrator is in Dubai, saying that's only 1 hour ahead. However, I'm involving leading counsel in that case, and my leading counsel is in Singapore. I am involved. I'm in the UK, and the president of the tribunal is in the UK. So that is going to pose some interesting questions, because obviously there's an 8-hour time difference between leading counsel and the people in the UK. And the reality is, I think in this particular case, we will end up, we haven't had this debate yet, but we'll have it shortly. And I think we're going to end up saying, well, let's start the hearing at 10:30 Doha, which would be, a normal time to start a hearing in Doha anyway. That means a slightly early morning for me and for the president, but 7:30 in the morning is not. It's not going to break the camel's back. It means a 3:30 p.m. start for leading counsel in Singapore. And so then I suppose what I will have to watch for is that we don't run too late, because if we're getting much beyond 4 p.m. Doha, 4 p.m. Doha will be 9 p.m. for him. But there have been plenty of examples I've heard of counsel in Australia or in America, getting up at 2 a.m. and that's when they're going to do their hearing. So the answer is it becomes the yeah, it's either the tyranny of the majority or it's the president that determines the time of the hearing. And I think you make a valid point that actually you may begin to see that slight tendency for people to think about time zones when they are appointing tribunal members. I think it's fair to say it might be a tiebreaker. If you had two brilliant arbitrators, one of whom was in your time zone and another of whom was in California, that might make you think, maybe I'm going to go for the guy in my time zone. However, if it's a brilliant guy in California and a in your time zone, then you're still going to go for the brilliant one in California, just because you want the right person. So I think that's how we'll see.
Well, Matthew, thank you so much for this presentation, for the time, and really me myself have benefited from this. I wouldn't say webinar, a lecture. I would say I like it so much, and I think we had a great attendance also as well today. And thank you again for cooperation under the name of the Chartered Institute of Arbitrators between CIArb Qatar and AACE Qatar. This is the first webinar we do and first cooperation for both of these reputable organizations, and hopefully in future we will do more. And thanks for giving us the chance by being our speaker today in this cooperation. Actually, in the name of the AACE and the board, I would like to thank you, and I would like also to thank the attendants who came today to hear this lecture. Thank you so much, Matthew.
It's my pleasure. I should say before we go, I noticed somebody raised a hand. Somebody called Francis raised a hand. I don't know if he was able to get his question to you. I feel bad.
He did not send anything. Yeah.
If someone raised their hand, well, Francis, do contact either any of me or Saad or Franco, if you have any questions about the CIArb or how we can help. Or indeed, if you've got any questions about virtual hearings, do get in touch with us. We're here to help out any questions that you may have.
We will send also the presentations to the slides on the PDF to everyone, and the attendance certificates to all the attendants who came today to help them better. Thanks so much, Matthew. Thank you, everyone, and see you hopefully next. I think after 3 weeks, we have another event, an interesting one. We already sent the invitations to everyone. So please stay tuned. Thank you so much, Matthew.
It's my pleasure. Thank you very much. Thank you, everybody. Bye-bye.